Good evening, everybody. Thank you very much for joining us. My name is Catherine Daly. I work for IOSH supporting the Singapore branch, and you're all very welcome here this afternoon to this presentation, which is how does duty of care apply at your workplace? We are very happy to welcome here two speakers, Mr. Jai, who was a former workplace safety and health inspector with the Ministry of Manpower, and he's got about 18 years of EHS experience, having worked with small to medium enterprises and two multinational companies also. And he's going to share his some of the legal implications. He's a certified internal auditor also. I'm sure he can introduce himself much more ably than I can. And he's also been helped along by Mr. Marcus Tan, who is an experienced in civil litigation, criminal defence litigation, as well as lead counsel and as well as matrimonial litigation as lead counsel. So without further ado, I'm going to hand over to these gentlemen. If I could just remind you that this is being recorded, so please keep your cameras off if you don't want to be on the recording, and the recording will be available later on the IOSH Singapore branch website. And also, if you could just make sure to keep yourselves muted during the presentation, and any questions that you have, you can put in the chat, or there may be a facility at the end of it to ask the questions yourself. So we can unmute people if they wish to do that at the end, because there's not huge numbers here. So without further ado, if I can hand over. Thank you. And you can share.
Sure. Hi, everybody. It's a good day today, Monday, last day in month of February, and we are happy to be here to present to you our topic for the day: how does duty of care apply in the workplace? So myself, Jay, and Marcus will be leading you through all the health and safety and legal perspectives of how does duty of care apply at your workplace. So what is duty of care? It is fundamentally a legal obligation for individuals or organizations for taking reasonably practicable steps. And what are these reasonably practicable steps for? Is fundamentally to ensure the safety and health of employees. This is the very, very fundamental thing that you should be doing as an employer. And it does not only apply to employer alone, it applies to every stakeholder who is part of the organization. So I'll cover on what I'm talking about in terms of the stakeholders in the later stage of this webinar. So let's go on. Firstly, we want to understand about this duty of care. When does it fail? Obviously, it fails when you are negligent. And there are three types of scenarios that you can have where you could fail. One is when you fail to check and review your work processes, which means like if you've got a new system in your organization, it could be a restaurant, it could be just an accountancy firm, and you have employed some new documentation software, and you have not checked whether are your staff spending too much of time, like eye fatigue, poor posture, and trying to figure out how to maneuver around those kind of systems. So you're also failing in your duty of care. And failing to follow professional advice. Professional advice in this context is mentioning about health and safety professionals like myself. If I'm telling my superior or the company's boss that you need to follow this because you're not doing it right, and they should be following those professional advice. If they don't, then it's an obvious failure. And the most obvious is when you fail to comply with the legal requirements. So let's move on. Let me share with you about what happened in a construction firm in Malaysia, where there was a workplace death involving a worker. It's quite a sad case because he had sustained severe head injury after a cement mixture, which was dumped from a by another worker from a height of a third story of a building and fell on the former's head, which resulted in him to go away from everyone. So this is a very clear-cut case of failing to ensure the duty of care as an employer, as a stakeholder. So as a stakeholder, this is where the other party, the worker, he failed to ensure that he's not doing the wrong thing, which constituted to the death of a worker. So in this case, the company was fined 35,000 ringgit Malaysia, but that's not all. We've lost a life. That's what matters most, right? Humanity, empathy. So how could you conduct a risk mitigation? These are 4 simple steps that you could do in your organization. First is always to identify hazard. So when you talk about hazard identification, we are talking about in your business process, you should be able to detect, okay, what are the high risk kind of activities that you are conducting, and how are you making it safe for the person who's performing the task to manage that? And in that situation, have you educated the staff on what he or she should be doing? And then how often do you revisit back on that same piece of work? This is called the process of risk mitigation, or in other industries, they could say that's a review of risk assessment. So this is very important. Your company need not be a very big multinational company. It could be just a simple company which is running day-to-day operations as an accountancy firm, or it could be not even having a physical office at all. You could be working from home all along from the day that you started working. But you still need to identify what are the potential risks. Is it ergonomic risk? Is it your workplace hazards in your home setting? Because as you would know, your home can never be the same as your office environment. And you would need to look out for trailing cables where you could trip and fall. You could be stepping on your kids' toys. I'm guilty of stepping on my kids' toys because I'm sharing the room with my son when it comes to my workstation. So I've already reviewed that and I tidied my place. So I'm safe enough to conduct this webinar with you right now. So you should take this moment to look back and think where else you could check back and ensure that all the control measures are in place, and importantly, they are communicated to whoever is going to use that space. That's very important. And in a company context, it's good to set up your own health and safety committee. Although it's a law in many countries where you need to have a certain number of employees before you start up your own health and safety committee. It's a legal requirement to do that anyway. But if you are feeling that having one, even if your company is having only 10 persons or 20 staff, you're definitely in good hands because you're having a team who's going to help you address all those risks for you as an employer. They're going to be your first shield to address any kind of issues that they are going to front in the shop floor, in the production floor, or in your office, or in your restaurant, or wherever your workplace could be. So they are going to help you to keep up the legal requirements. How are they going to do that? Because they're going to convene at least once a month to discuss, has there been any new requirements under the workplace safety and health that we need to be aware of? So they're keeping minutes, so it's being documented. So that's very important. And they also help you to regularly review your work processes and work instructions, because as part of the legal requirement, when you do a review of your work assessments, you need to look through all the processes, so which gives them a lot of time to spend and ensure that there's no deviation from what they have last agreed on, and has it been communicated to staff. Like I mentioned, communication is very, very key when it comes to managing workplace safety and health issues, because in my understanding, I've been practicing for 18 over years, and the key thing that was fundamentally lacking was communication. It was not passed on well enough to all the parties involved. Sometimes it just stops at certain levels and it's not reaching to the last man on the line. And your health and safety committee definitely is in the best position to advise senior management of the risk and the impact, so that they could make informed decisions of how they could strategize a plan to address the issue. Like, for example, if you're feeling like your your workplace doesn't have an isolation room in the context of COVID-19, and you don't have proper means to have an isolation room, it's very touchy, right? You wouldn't know how to manage this part of the legislation. So you could have a discussion, push on to your senior management, tell them, how else can we manage this? So it's always good to have a team with always providing the senior management with the informed decisions. And definitely this health and safety committee is going to be the go-to team for advice on anything pertaining to health and safety. So if an employee has got an issue, he need not come and look for the general manager. He could just go to the committee and ask them, I've got this issue. My workplace, the lighting is not turned on properly. I can't view my path. There's a tendency that I could not be seeing something on the floor. So he didn't have to go all the way up to the facilities manager or the general manager. He could just go on to the health and safety committee who could help him or her address this issue. So this is the value that you can get. And now let me pass on the time to Marcus, the litigation lawyer, to take us on how does it look at it from the legal perspective. Over to you, Marcus.
Thank you very much, Jay. All right. So I'm Marcus. I'm a litigation partner with Solitaire LLP. Right. So what I'm going to do now is to give you some bit of background so you understand why workplace and safety hazards are important to you before moving on to a case study that's used in Singapore law at this moment as to how to determine the liability of the workplace when it comes to workplace accidents. All right. So I've got some statistics from Straits Times as well as the MOM websites, right? Of course, falls from height are the leading cause of death, but that's more affecting the construction industry as a whole, right? But putting aside the construction industry, there are many other injuries that can come about from workplace accidents, okay? So for example, I think slips, trips and falls are another leading cause of major and minor injuries, right? And this affects industries that are apart from our construction industries, including cleaning, transport, security, food and beverage sectors, you know, even in your offices, right? These injuries do happen. So don't think just because, you know, you don't work in a construction site, workplace safety and health doesn't really apply to you, all right? In fact, MOM has done quite a number of inspections on a number of work sites, and up to 55% of workplaces have actually contravened some form of workplace health and safety measures required. So you may think that you've complied, but most likely there are many things that you have not done, all right? And I have to stress that even workplaces that are office-related workplaces, right? There are other injuries arising from that. In fact, work-related musculoskeletal disorders are quite common. Poor sitting, you know, in your chair, improper tables and chairs alone is considered some form of workplace safety health issue that should be resolved as much as possible for employees, right? And these may contribute to contraventions, because if any injuries arise from this, then you may still be liable, or even then your employees may take action against you. Even though they haven't, they might, or they have a right to do so, all right? So let's focus on the case study, because this is the case that is applied by the Singapore courts when determining whether an employee or employer is criminally liable. That's putting aside civil liability, but we talk about criminal liability first, all right? This is a construction industry example, but the same factors apply regardless of whether you're in the construction industry, you are in food and beverage industry, or whether you are in office for itself, all right? So what happened in that case was there some negligence on the part of the construction foreman, all right? The construction foreman, of course, is the supervisor of that area, and that resulted in the death of 2 workers. It was initially a fine being imposed on the construction foreman, right? But the prosecution was not very happy with that. They appealed the decision, and it ended up in a jail term, okay? Now, there are many factors to be examined by the police and the relevant ministry when they come to decide whether you will be liable or not for any potential harms that arise, all right? Any regulatory body will look at it. So what you need to consider whenever you constitute your body, right, to examine whether you should or should not put in place measures include the seriousness of harm. All right. If there's a possibility that someone will suffer a heavy injury or death because of a workplace issue, you definitely need to do something about it. All right. For example, in the construction industry, if you fail to put on your harness, somebody might fall and die. That's something you need to consider. Next is the likelihood of harm arising, because we have to take a very practical measure. Not every harm will arise. I will not expect that, you have to protect against everything. For example, people getting scalded when they get water from a water cooler. There's a chance of it arising, but the seriousness of the harm is low, right? These are things that will be taken into consideration as well. And of course, finally, the number of people that will be impacted if you fail to properly put in place measures. So for example, if you're talking about an office environment and a fire occurs, right? The harm is high. Whether it will happen or not is a big question mark, right? Maybe it's not so likely that will happen. But if a fire does occur, a lot of people might be exposed to the fire. A lot of injuries might occur. All right. So that's when the court will look at how culpable you are. All right. If you're not prepared for any of the above, then the court will consider. All right. Moving on from this slide, the nature of the unsafe act. All right, and the number of acts committed by the offender. So let's say it's a simple thing. Every day, you don't ensure that your documents are placed safely in the office. You don't ensure that the fire extinguisher is easy to access, right? And if a fire occurs, then you could be more liable. A number of unsafe acts. So for example, if you don't ensure that every day, the floor is clean and dry, if you work in a high risk environment, like a kitchen, for example, or you don't ensure that they put on the proper work safety equipment in the construction industry, the proper non-slip boots in industries where you work in a wet environment, right? That is something to be taken into account, especially if you don't enforce it, all right? And the level of deviation from the established procedure is one thing. It's one thing to have proper procedures put in place to ensure that the environment will be safe. But it's another thing for people to follow these established procedures. So I will stress again, all right? Just because the man on the ground doesn't follow procedure doesn't mean the person who's high up there will escape liability, all right? So let's give a good example. If a secretary fails to follow the procedure, the secretary's supervisor might become liable, all right? If there's no workplace health and safety committee put in place, then the director of the company might become liable. So if an accident occurs because a secretary fails to do something, her immediate superior is in trouble because she failed to ensure that it will not happen. If there's no established procedure in place, the director will be liable because he failed to ensure that certain steps are put in place to minimize accidents. All right. So don't believe that, just because you are from very high up, you have no influence over the man on the ground means you're safe from any liability or culpability. That's not true. All right. You need to put in place hazard safety assessments to make sure that that these things don't happen, or if they don't occur, they occur because of a freak accident. You need to ensure that the man on the ground understands the procedure, and you need to make sure not only do they understand the procedure, they must follow the procedure. Any deviations from any of these points would mean that you could potentially be liable. And I would say that liability is not only criminal in nature, where the regulatory bodies and the proper authorities will step in. It may also expose you to civil liability, where the person who is injured can take action against the company, and you will be made to pay out for any of these injuries, whether it's a short-term payout because of a minor accident or long-term payout where there's significant disabilities. So you do have to consider all of this when before deciding whether you want to put in place any form of workplace health and safety measures. All right. Of course, the best person to help you advise whether you have done enough will be Jay. But for me, I'm telling you, if you don't do it, you will be liable. All right. So from here, I can move on to some of the frequently asked questions. I think Jay can help to handle some of them as well, right? So some of the very common questions asked, of course, is what's the basic requirements, basic requirements, okay, to put in place. So Jay, you
Yeah,
can take it from here.
sure. So one of the first question is that what is the minimum or basic requirement for me as an employer to comply with the local legal requirement? So, because as you know, employers always want to know what's the quick fix, right? So the quick fix is, at the very least, you should conduct a workplace risk assessment, just like what Marcus mentioned. You have to conduct your hazard assessment of your workplace that covers your business operations and ensure that this is being followed up in terms of all mitigation measures so that your workplace is safe, not only for your employees and also for your non-employees, because as an occupier of that workplace, you are liable for anything that happens under that roof. Next question. What is my liability if I do not fulfill my responsibility? I wouldn't dare ask this question, but I've been asked this question many times. So here it comes. So it simply varies from just paying penalties or depending on the severity of the issue, which could include a jail term too. And the jail term is because of what Marcus earlier mentioned. It could be penalized by the authorities for failing to comply with their legal requirements. But if it is going to be a civil case against you, where your employee is taking a case against you for not informing him or her of what he could have done or he could have done to keep herself or himself safe from that situation. So that's how your jail term could be pending. So please do not get into that kind of a trap.
I should add that the jail term doesn't only come about because people die, okay? Significant and severe injuries or flagrant breaches of any workplace health and safety rules or procedures can likewise attract a jail term. So just because you have a procedure in place and people do follow it, if somebody just doesn't care enough to follow it and it leads to a significant injury, even in cases where it may not lead to a significant injury, there is always the possibility that someone gets a fine and a jail term. All right, so don't take it very lightly. All right, especially if it has been occurring a lot and you fail to take notice of it. That's of course more grounds for the authorities to say, you know, we've been telling people this has been happening and you don't do things to prevent it, then be warned, you might be forced to pay more penalties. All right.
Yeah. And one other thing is that having the pandemic as an excuse is definitely a big no. So you will still be penalized. So please be mindful. Next question, is it important for me to communicate the safety information till my last employee, or is it sufficient for the supervisors to be aware only? I think most of you would have already got answers from me much earlier in this webinar. Safety information has to be communicated with all stakeholders of your business, which includes your employees. Because without communicating, you're not doing any good from all the best stuff that you've done. So please be very sure that you're communicating every piece of information. It can be in the form of an e-newsletter, it can be form of an email, whichever means we are not going to stop you at, but as long as it's reaching to the audience that you're targeting at. And if it's good, you can get some acknowledgement, like a thank you for the message. But even if you don't, at least you have done your due diligence to ensure that you have communicated that piece of information which is useful to them.
Yes, I think that's quite important. So quite common, right? Of course, is if you work in the office, have a meeting, make them sign at the end of the meeting that they have attended such a briefing. That's a very simple way of saying, hey, on this day I held a safety briefing, you know, they sign on it, they acknowledge that they've listened to it, you know, so I've done at least some form of due diligence. That's for office environments. For construction, of course, normally, you know, they have a lot of they have a lot of briefings in the morning. So these are some of the hazards. Make sure you follow this, make sure you follow that. So everyone would know. Everyone would know because they were all in the briefing that they have to do certain measures. Simple things like that can help to protect you because it shows that people have at least attended the briefing, and any deviations, of course, you can at least, I wouldn't say push the blame, but you can at least say that, you know, this is the individual's failure to take proper care of themselves. In civil liability, that will reduce your liability due to contributory negligence. In in regulatory offenses, you can at least say, you know, I've done really my best. He chose to disregard the rules recklessly. He has, of course, paid some form of a consequence, but we will try to say that it's not our fault. It's not our fault. We have done something. All right.
Right. So let's move on and let's hear from you, people out there. So
I see some
I
chats,
understand that
some question in the chats as well.
yeah, I think there's two questions for you, Marcus. I think the first question is okay, JK Tan. Thanks for the question.
I think
so
it's both relating to the construction industry. So I would take them both as a whole, right?
sure.
JK Tan, thanks for the questions, right? I think the court is not trying to send the wrong signal, right? What the signal the court is trying to send is that it doesn't matter whether you are a man on the ground, his direct supervisor, his direct supervisor's supervisor, or director of a company. Safety is everyone's responsibility, all right? Of course, it does seem a bit harsh to send project managers and project engineers to jail sometimes because sometimes they're very far divorced from the action. Sometimes they're not the ones on the site, right? But if they had failed to do even the most basic care, right, even the most basic care, then the court will ask this question: why have you not done it? You know, do you not feel that it would be part of your responsibility to take certain actions? Have you not considered that if you had put in place these measures, these accidents might not have occurred? Okay, so project managers and project engineers can be found liable, especially if they've been pushing the project just to follow timelines and recklessly disregarding safety. Our clear examples, of course, are the collapse of the highways, right? Both at the TPE site and of course the Nico Highway, right? Where they were just trying to hit their timelines and hit their project deliverables. That's where they might be personally liable because they have disregarded safety at the cost of profits. All right. So it's not that they will just fine you or send you to jail in cases where there is an accident. But if you have ultimate responsibility, you have to show or demonstrate that you have done your part to discharge your ultimate responsibility. Okay. And after that, any deviations from the man on the ground, you can at least try and put some protection on yourself and say, you know, Your Honor, it's not that I haven't done my part. I've done this, and this. Every morning we hold safety briefings for the employers. We stress to them that they must follow these procedures because there is a chance that they will lose their lives or suffer severe injuries. We have told them that we have put in place these things. We have bought these supplies for them. After that, if they fail to do their part, then it's really out of our control. That's where your shield comes in. All right. Jay, you have anything to add to that?
Yeah. So to add on, because project managers and project engineers are technically required to perform their role on the projects, so which means that they are bounded by the project limitations, which are like permit to works, which are all gateways before allowing something to happen. So in this case, they didn't fulfill the responsibilities in the role or the function they are playing in that project, and that's why they were targeted to address the issues. And when they were found guilty, and that's how the penalties were meted out. So it's not wrong of you to think that it is a wrong signal, but actually it's indeed the right signal because it's targeting to whoever should be accountable for the act, which could have been prevented.
True. I think they're trying to tell them that, you know, just because you're someone very high up doesn't mean you can escape your liability. And they found the perfect case to do it. So it's not that every cases hit jail terms, okay? It's only the cases that you see in the news that they've hit jail terms, but that's because they've so egregiously breached their rules and their roles and responsibilities that they will hit the news. Then they'll send one signal, one time, go to jail, then everyone else will be, okay, maybe we should do something about it. So, but most cases, I think they have put in place most procedures so they escape liability. Not fully, but at least there's no jail term or fines. So that might be something you can consider. So you do your due diligence and to make sure you put in place proper rules and procedures so that you escape liability. All right. I think the other question I have, of course, is a recent case of a falsified certificate as a workplace safe health organization, right?
Yeah.
Who will be liable for that? Well, firstly, anyone who falsifies documents, there is criminal liability. All right. So don't sign anything that isn't real, right? Don't make up documents just for the sake of making up documents, because when they find you or if they catch you, not only do you suffer the original penalty, you suffer additional criminal liabilities, all right? As long as the management is well aware of this, the management themselves are liable. As long as the management did not put into place procedures, but they pretend that they did and they ask someone else to do it, they can also be liable, all right? Of course, the degree of liability depends on how complicit the boss is. If the boss gives direct directions, right, then he will be fully complicit. If the boss tells the HR, for example, go and get it done. I don't want to know how you do it, but you go and get it done. They may still be indirectly liable. Of course, if you hand it over to the HR entirely and the HR didn't do it on your instructions, then the HR falsifies something, then the HR may be personally liable. So at the end of the day, the ultimate decision maker takes the responsibility. Okay, the ultimate decision maker. I think there's a question for Jay, actually.
Yeah, from me, from Andrew. Thanks, Andrew. So the question is, when companies are going to Singapore to set up their operations, what should they do first to start meeting with the health and safety obligations in Singapore? Okay, so what should be done is that because their first time, the new startup, or they're expanding the business into Singapore, so the first thing they should be doing is to engage the services of a consultant who will be able to run a health and safety gap analysis so that you can identify what are the legal requirements required in Singapore against what the business should be complying with, and then to provide them with a report and recommendations. So from there, the company's management should be able to have a sensing of what they have and what they do not have, and they should pave their path forward from there onwards. So that should be the first and simplest way to get around this. If not, it will be like a rat race where they're trying to understand what are the local changes that's happening is going to be very crazy. So always start off with the health and safety gap analysis, because that's going to be the first step to identifying exactly what you need to do so that you can use your time productively, and you will need to know whether are you going to employ someone else to support you with those action items.
So, I think Jay has really covered that point very well. Yes, please start right. Please start right. If not, you end up seeing me. You can see him or you can see me. I can tell you, if you see me, then you're going to pay a lot more than you have expected. Okay, a lot of people think that it won't happen to me. It will. It might. It may not. But at the end of the day, it just depends on how much risk you're prepared to take. So I do encourage you strongly to start up fast. See Jay, for example, early. If you don't feel like you have the capability to meet the workplace safety health requirements, see him early so that they can help you to hit these requirements, right? Even seeing them at the start can save you a lot of trouble in future, okay? What is my most, okay, I think there's another question from Nurul. What's my most memorable case? For me, I've seen quite a fair bit of workplace accidents. Sometimes when the photo comes out, it gets a bit gruesome. Right, of course, lawyers are hopefully with stronger stomach and trained to look at the pictures without wanting to throw up. In fact, I look at it with some fascination. Okay, but there's some people who have gotten their hands completely mangled. It felt very unnecessary because they had the gloves, but they just wanted to do it for convenience. You know, they just like, okay, you know what, I'm just going to do it faster, and then they lost quite a number of fingers and a long-term injury, no longer able to use the hand. So that's where I always tell people, you know, it might take a bit longer. It may be a bit of inconvenience, right? But please do take the extra step to protect yourself. At the end of the day, of course, both parties were equally liable in some way. The employee was liable because they provided the equipment, but he chose not to use it. The employer supervisor was liable, but not for criminal sanctions, more for the civil side, right? Indirectly, the company was liable because they failed to ensure that he followed properly established protocol, even though on his own, he's the one who failed to do it.
Next question from Ashri. What can be done for executives like us where workplace non-conformance and bad employment practices is done by the company where we do not wish to be seen as a whistleblower, but we still have a rice bowl to care for? So his concern is on what can be done to protect executives like him in terms of whistleblowing and not being affected. I think I can take this up first. Whistleblowing is supposed to be a regular right for any employee. I would think so, and I believe I'm correct, because there's no law that's going to say that you can't raise your flag and say that there's a wrongdoing, which is endangering your safety. So the first thing is that when you feel that your workplace is unsafe, you should not proceed with the work. I understand where you're coming from, Ashri, when it's a rice bowl issue where this is how you're supposed to be performing your role, and you're not getting the support, and you don't know where else you could lean on. So the place you could raise your flag to is the Ministry of Manpower, where in Singapore, where in other parts of the region, you could go on to your health and safety departments, because they will be very happy to help you anonymously, because that's what they want. They want to understand what's happening on the grounds, because they don't get to see what's happening on the grounds. So once they have some information, they will know how to tactfully manage that and address the issue. So never keep in silence, because if you notice something which is wrong, like for example, if you saw something like a near miss incident that happened to you or to someone else, and you're afraid to raise that as a concern to your senior management, being afraid of being fired, for example, what happens is that if this is going to be a regular incident that's happening over the weeks, and one day, boom, you get an accident, and it's worse enough if someone is dead or has lost a limb, then you'll be feeling very miserable. So in order to feel guilt-free, always stand up for your rights and speak up. Never be afraid of being penalized, because I can say, because coming back from a Ministry of Manpower background as an inspector, I've had a lot of emails coming in during then. So we will not reveal to the company why are we coming down for the inspection as well. It's a random inspection, and we are authorized by the Gazette that we have the power to enter any workplace. So I hope I've answered your question.
Yeah, I think Jay really has hit the nail on the head. A lot of you feel that you see workplace performance and you don't want to raise it because you're afraid of being penalized, right? You shouldn't. Firstly, it protects your rice bowl in a way, because any accidents that occur will always adversely affect not only the company but possibly you as well. All right. You don't have to approach it from the sense that you're complaining about the situation in the company, but just raising a concern. Even a simple email say, hey, by the way, I saw this today, someone almost got injured. Can you please do something about it? That in itself can help to save you in the long run. All right. So don't feel like you cannot share your concerns with any company. I'm sure any company will be happy to try to put in place something that will prevent further accidents. If they don't, of course, then that's where, of course, they'll be liable themselves. I hope they understand that there are consequences for not caring. Of course, if the cost of implementation is very high, a solution, I would understand a little bit. But at least the very bare minimum would be, at least they think about it, and then they will decide for themselves whether they want to implement it. All right. So that's all I have to add, because Jay already covered the most of it. I think there's a question from Andrew. I'm happy to take that. Level of fines vary a lot for workplace safety failures, and by doing things right, what can a typical company save? Okay, the level of fines can vary, all right, depending on how much injury was caused. If it's a minor injury and it's easily preventable and steps were taken to prevent, the fines, of course, will be very low or unlikely to occur, especially if you put in place a robust set of procedures beforehand. But if you don't, and the injury tends to be very high. So for example, something like ensuring that the fire extinguishers are filled, right? And a fire occurs, then of course the liability or culpability consequently goes up significantly. Even by doing a simple test, right, of ensuring that everyone is aware of their workplace safety and health obligations, right? In the event that accident does happen, you get to cut down a lot of liability for the company, not because you can show, hey, look, we've really tried our best. These are things that happen beyond our control, right? You can save a lot in the long run. I know some people think that, I'm not willing to shell a little bit of money to make sure that I have proper workplace safety and health procedures, because I can do it on my own. You may be able to do it on your own, but sometimes I think it may be better to approach an expert, right? the $3,000 or $4,000 or $10,000 even that you spend today can save you from $100,000 to $200,000 worth of professional liability or liability on the part of your firm. And of course, the long run is you may pay less in insurance because insurance premiums tend to go up after accidents, right? Workplace safe environment means lower insurance premiums, right? So don't think of it only as a one-time cost that I'm not willing to pay. Think of it in the long term. And you can always just update. The updating is less expensive, of course, than putting in place a set of robust procedures in the first place. But shout out for the initial plan. Shout out for the initial plan so that in the long run, you save money. Okay? Anything to add to that, Jay?
Yes, you're very, very true on that, because you need to be very focused on what you want out of your business. If you're wanting to make profit, you need to make sensible judgments in the start. So proper planning is very important, which is how the risk assessment comes in. So it's a logical thing. You need to understand what are the risks that you're going to be open to. So you don't want to be an open target in the war field. So plan first and then act on the X according to your priorities.
Yeah, I think
next question.
Okay, let me just deal with the communication one first, right? Before we move on to the newsletter part. He has asked whether communication evidence like WhatsApp are sufficient to be used. Yes. Okay. Any form of communications will serve as evidence in court. Any. So be it an email, although lawyers tend to prefer emails itself, WhatsApp, Telegram messages, video recording, any of these will hold up as evidence in court. So if you have informed the management, but they fail to do something, the police, for example, have the right to seize any electronic equipment they deem fit to their investigation to determine how liable you are. So for example, they will seize your laptops, they will seize your video recording, they will seize your voice recording if they feel that it's necessary to show whether you've committed an offense. All right. So communication evidence is important, right? That's why I say but lawyers, of course, prefer written communications if we can. Easiest to show and easiest to understand. Okay. So Jay, let me hand that over to you now.
Sure. I think Marcus is right. I think understanding about messaging, even if you deleted a chat, I think there's a way to still retrieve the information. So it doesn't mean that you've deleted information off your phone. It's gone. It's somewhere in the galaxy and you can still reach us back. Next question is on the newsletter. When Nurul is asking whether is there a newsletter or website that we as EHS professionals can sign up for to receive newsletter and best practices to keep in date on legal requirements. From what I've seen, there's a lot of companies which are providing this as a paid service. And likewise, you can look me up. I can also work with you all on how and what kind of legal requirements are you looking at, because not every industry would want to be open to receiving all the updates that you wouldn't want to receive in an email. So you could send an email across to me at j@mckinnconsultancy.com and we can have a chat around what specifically is your need. It's all about tailoring to you what your business needs are. And of course, you can also go on to the Singapore IOSH website where they have got constant updates as well, which is happening on a regular basis. So if you're an IOSH member, you're already privy to those kind of information. If not, you should just hop onto their website to get the information.
Okay, we have no further questions. You can always feel free, I'm sure, to contact Jay and myself. Our contact details will be available with you somewhere, I'm sure. But do feel free to ask, right? I don't think it costs you much to ask, but it might save you a lot in the long run, all right?
Yeah, and I think to just add on to the topic, how does duty of care apply at your workplace? Asking to know knowledge is also your duty of care, because you're in a position to answer for anything that happens in your organization. So feel free to take the time and list down all the questions that you have, and you can reach me at my email contact, as in here, j@mckinnconsultancy.com. So I will pass on anything which is legal on to Marcus, and he will reply to you all directly from there.
Thank you so much, Jay and Marcus. It has been quite an informative session. Thank you once again for sharing this session with all of us in IOSH members as well as IOSH non-members as well. And as a token of appreciation, Marcus, we've got a certificate to present to you. So this certificate will be sent to you via your email as a form of acknowledgement for your time that you've taken to spend with IOSH Singapore branch members as well as McKinsey EHS contacts as well. So before we leave you, this session is recorded, so we will be uploading a copy of this presentation on IOSH Singapore branch website. So if you've missed the details and if you want to find out more, or if you want to have another listen to the conversation that we've had, please come on board to IOSH Singapore branch website and you will be able to download this presentation. So once again, thank you so much for all your time, Jay, Marcus, and for all those in attendance.
Thank you very much. Happy to help.
Thank you.
Thank you.